application in the matter of Vodafone Group and others and security of distribution and
Yes, Mr. Hinchcliffe. We've read the various judgments, we've read the skeleton arguments, we've read what the Supreme Court had to say. We understand the problem. The question is, can we do anything about it?
Indeed. Well, my Lord, my first submission was one I can probably skip over, which was going to point out that I'm not Mr. Mitchison.
Yes.
For Vodafone before your Lordship last time. So what I propose to do is first a little bit of a brief background to the chronology of how we've got to where we've got to, then deal with the relevant provisions of the rules to address whether why we say your Lordships can do something about it at this stage, and then deal with the issue of, if you can, whether you should. And as you've seen, the application has been made under Rule 3.17 because Vodafone's taken the view that the 5230 doesn't apply. However, both of us have addressed 5230 in our skeletons and the provisions of it. My Lord, I would say that if your Lordships take the view that that is the appropriate course to take to give the relief to Vodafone that they're seeking, and obviously I'm not going to stop your Lordships doing that.
But there's no alternative application under 5230.
There's an application to set aside pursuant to 3.17.
Yep.
So there's a general application to set aside. And my Lord, my submission would be if I had made an application without specifying the rule in the application, I could pursue both grounds.
Oh.
It actually refers to 3.17, I thought.
It does. I mean, I looked at it quite carefully, and as far as I can see, there is no application under 5230.
No. So well, if we can deal with the chronology briefly. So could your Lordships take the supplemental bundle?
This is all in Mr. Brown, isn't it?
Well, I'm going to do it by way. There's a helpful chronology to the back of the Supreme Court's application for permission to appeal. And that might just...
Right, chronology is...
So it's S tab 1 and it's page S22, which should be the last page or so of that tab.
Yes.
And so now the priority date and the filing date of the patents, as we see at the first couple of lines, was 1999 and 2000. By way of background, IPCom purchased their patent portfolio from...
I beg your pardon, Mr. Hinchcliffe, it's entirely my fault, but I've failed to find the page.
It's page S22 at the top, which should be, if you've double-sided, my lord, it's the last page of tab 1 of bundle S.
Oh, yes. Thank you, my fault.
So
yes.
Priority dates of 99 and filing date of 2000. And IPCom purchased their patent portfolio from a company called Robert Bosch, and have been enforcing that in this jurisdiction since around 2008. And that was including enforcing it against my clients from around that time. The patent was granted in 2016. I think it's a third generation divisional patent that's been divided out from the main application several times. And as we see from the chronology, there was an initial claim form was issued in October 2018, so that's 2 years after the patent was granted, and that wasn't in fact served on Vodafone until February 2019.
Just pausing there in the chronology, you've got a window to start opposition in the EPO after the grant.
Yes, my lord.
And I understand that it was a German Vodafone company that was the opponent. When did that start? It's not in the chronology.
Well, it would have...
And I couldn't get it from Mr. Brown.
My lord, it's a 9-month window to do it, and the way things tend to work in the EPO is the oppositions go in right at the end of the 9-month period.
So 9 months
not only that, if you file early, nothing happens, because what the OD does is it waits until the 9-month limit has expired to see if any other opponents come in. So the practical reality is, regardless of when the acquisition is actually filed, it has no effect until the expiry of the 9-month window.
Right. So the window closed, is this right, before the claim form was issued?
Yes. Yes.
And so when the claim form was issued, everybody knew that there was opposition in the EPO.
Indeed. And of course, as soon as the patent was granted. The patent was granted in the period when IPCom was seeking to enforce its portfolio against Vodafone more generally.
Yeah.
So then, May 2019, there was a hearing before Mr. Justice Burse, where there were a couple of issues before the judge. And in particular, IPCom sought expedition of the action. And the reason they sought expedition was that the patent was going to expire in February the next year. And they wanted the trial to come on quickly so they could get a judgment and hopefully
Get an injunction
or put my clients to the
Right.
to the
I'm
choice
sorry
of
to
taking a
bombard you
license.
with questions. I've got another question. Mr. Brown says that Vodafone applied for a stay. I've read Mr. Justice Burse's judgment, and the application for a stay seems to have faded away.
Yes, well, I was going to come on to that, but I can deal with that now if you'd like. So there was an application for stay that was dealt with in evidence and in the skeletons. And obviously, my lord, I wasn't there, but what happened was that it became, firstly, the judge was plainly aware that the application for a stay had been made, and he was aware of the opposition proceedings because he refers to it in his judgment. And what Mr. Brown explains, given I think the way the wind was blowing, Vodafone took the view that resisting the application for expedition was as good as the stay, because that would mean that the trial would come on after the patent had expired, and there would be no chance of any injunction.
Yes, but there would have been the chance of damages.
Yes,
And sometimes the price of a refusal of a stay is an undertaking to repay any damages that might be awarded, but that doesn't seem to have been under consideration at the time.
that wasn't advanced. The other submission I would make in relation to this is that given that the judge knew about the existence of the EPO proceedings, but nevertheless expedited the case, my submission is even if the application had been advanced orally, it would have been refused.
Well, it might have been, but it might have been refused on terms.
Might have been refused. It's possible. Now, so then going back to the chronology, in shortly after the hearing before Mr. Justice Burse in September 2019, the opposition division had their hearing where they upheld the patents in an amended form. Now, does my Lord Justice Lewison and my lady, do you understand would you like me to explain the relationship between the EPO and the English proceedings and how that can come about? Would that be a helpful 2 minutes?
Very, very shortly, yes, please.
So the patent is a European patent. It's granted centrally by a body called the European Patent Office,
Yes.
which is set up under international treaty, nothing to do with the European Union. When the patent grants, it grants in all the contracting states as individual national patents. And so the primary route to revocation of those patents is via the national courts. The one exception to that is the opposition procedure. And as my Lord puts me, there's a 9-month window in which any party can apply to oppose the patents on the same grounds that they could in national proceedings. And if that opposition is successful, the patent is revoked centrally. And that's the difference, whereas if you revoke in national proceedings, it revokes only in that court.
Yes, but it's worth explaining that the problem that we nowadays face arises because of two things that were not anticipated by the architects of the European Patent Convention. It was intended that opposition would be a speedy way of centrally knocking out a patent early in its life. What was not anticipated was that first, patents would be granted so long after they were applied for. We see that as a good example in the present case, where the filing date is 2000 and the patent is not granted until over 16 years later when it's well on its way to expiring. So that's the first problem. The second problem was that it was envisaged that opposition would be a speedy procedure, but due to the EPO being a victim of its own success, it's turned out that there are so many oppositions filed that the office can't handle them quickly. It takes time to deal with both at first instance and on appeal. And so opposition proceedings can easily last, even now, 5 years, let alone when there was a tremendous backlog, which has now been partially alleviated. So that's why we have the problem. Because if you had a scenario whereby, as was intended, patents were being knocked out centrally by the EPO opposition procedure at an early stage in their life, whereas revocation proceedings are typically later in the life of the patent, then these problems wouldn't arise.
No. But it is the case that even if the procedure had happened as it had been hoped at the outset, parallel proceedings, parallel opposition and national proceedings is always an inherent part of the system.
To be sure, yeah.
So then going back to the chronology, first instance trial was in January 2020. Between trial and judgment, the patent expired in February 2020. Judgment was in April, and after judgment, or in the judgment...
well, so that's not quite right, because the substantive judgment was in January, and it was the form of order judgment that was in April.
Apologies, my lord, I'm reading the wrong thing. The trial was in November. The judgment was shortly before expiry. But because the judge had found that he largely accepted the Crown use defence and therefore found that the extent of infringements was very small, the patent expired then before the form of order hearing, so there was no injunction granted. Over the page, your lordships come onto the scene, and the hearing before your lordship and your ladyship was in January 2021, where you allowed the appeal in relation to Crown use but dismissed the rest of the appeal. So the patent is, after the judgment of this court, been found to be valid and infringed. And then, so permission to appeal was applied to the Supreme Court in March 2021.
Now, I'm sorry to interrupt you, Mr. Hinchcliffe. Again, another thing which is absent from the chronology, but it doesn't much matter as far as the details is concerned, is that as we do see from the chronology, the written reasons for the opposition division were in March, and there will have been, I forget what the time period is for filing, I think it's 2 months or something like that. But obviously there would have been, I assume, probably appeals by both sides, one against the decision to requiring amendments, and one saying it should be knocked out in totality.
Yes. Yeah. So then the hearing...
So as at the date of the judge's order, there would have been probably no pending appeals, but everybody would have known that there was a likelihood of appeals being filed by both sides.
Yes, and as I'll come to show you in a moment, so the issue of the appeal hearings was raised before between the parties before the hearing of this.
So I think it would be helpful for us, just so as we can get the chronology accurate, if you could just give us the dates, not now, but after the hearing, the dates when the various EPO proceedings were filed at first instance and on appeal, just for completeness.
Of course.
Together with the relevant deadlines.
This chronology, which was attached to the permission to appeal application, obviously was written before the TBA hearing, but the TBA hearing took place as scheduled, and the patent was revoked. And what happened thereafter was...
and we see it's helpfully explained that you were able to get the Technical Board of Appeal hearing expedited.
Yes.
But nevertheless, the hearing came 5 months after our final order.
Yes. After that, there was an amended grounds of appeal put into the Supreme Court, referring to the fact of the revocation of the patents. and then the Supreme Court.
So where do we find that?
The amended grounds are in tab 6.
And am I right in understanding the relevant application notice is the one at tab 5?
Yes, my lord. And it's the paragraphs in tab 6. It's the paragraphs in red. New paragraphs 1 to 11 raise the fact of the revocation as the ground of appeal.
Yeah.
And
we see from paragraph 11, it's slightly curious. I mean, maybe you can explain this a little further. I hadn't quite picked this up until I looked at this. Paragraph 11 says, if Vodafone is permitted to amend these grounds to introduce the paragraphs above, then the remainder below can be deleted. So, am I right in understanding, therefore, that the application is, as it were, a conditional application to amend your grounds before the Supreme Court? That is to say, you want to substitute grounds relating to the costs order, but you say if you're not allowed to do that, you're maintaining the appeal on Crown use. Is that right?
My lord, I'm told that our application is not conditional, that the remaining grounds have been left there for information, that the application now is to amend, to rely upon the revocation.
Right, so notwithstanding what paragraph 11 says, we can proceed on the basis, can we, that the appeal on Crown use has been abandoned?
Yes.
And that's perfectly understandable because, of course, it's now academic.
Indeed, it would be a waste of everyone's time.
Yeah. Thank you.
And then, as your lordship indicated at the outset, the last factor in the chronology is the direction of the Supreme Court, which you've looked at, where they asked us to think about what we should do and if we thought appropriate to apply to the Court of Appeal, and here we are. So that's the chronology. I was going to give you a little bit more detail about the approach to the listing and the interplay. I think I've probably dealt in as much detail as I can with what happened before Mr. Justice burst, that the application for a stay was made but not advanced orally because of the way it was going, and the fact that the success in the expedition would have meant no injunction. Can I just show your lordships just a little bit of correspondence in relation to the appeal, because the same point was made in relation to the appeal. So this is the supplementary bundle again in tab 8. Sorry, my lords, tab 11.
Tab 11.
Tab 11.
Yes.
So this was before the hearing before your lordships, and there's a letter from Hogan and Lovells on the 1st of September to Bristow's, and perhaps if you could just read the first 3 paragraphs of that letter to yourselves.
Yeah.
And then on the next page, there's the response from Bristow's, and it's the second half of the first, the large paragraph.
Yeah. So Bristow's don't agree to adjournment.
Don't agree.
But you take that at face value and don't apply to the court.
No application made, but the point was raised, and the point about the potential wasting of the court's time was raised. So, with that, can I turn now to the relevant rules? And what I'd like to do is address 3.17 first, then perhaps very briefly touch on 5230, but there may be not much point in labouring that one, and then finally deal with what your lordships should do.
We haven't got that in our bundle, so we'll take it in the white, presumably.
So we start with 3.17. That's The rule itself is on page 105 of the 2022 edition, but it's also in our skeleton in the tab 4 of the core bundle
Yeah.
as well.
I think I'd rather look at the rule itself, if you don't mind. Yes.
So Rule 3.1 starts on 104 and it's on page 105. A power of the court under these rules to make an order includes the power to vary or revoke the order. Now, a few general submissions at the outset. That's obviously expressed in the very general terms. It's not limited to any type of order. Its face, it's not limited to interim orders. It covers both interim and final orders. It's not limited in time as to when the order can be varied or revoked. And nor is it limited only to its application limited only to before the order's been sealed.
Say that last bit again?
It isn't limited to orders that haven't been sealed.
No.
The sealing of the order plays no part in the rule.
Yeah.
Now, of course, that doesn't mean that the court can vary or revoke orders lightly or easily, and certainly not so as to conduct appeals from itself.
Well, quite. So it's implicit in what you've just accepted. You accept that Rule 3.17 can't be construed in isolation, but must be construed by reference to the rules as a totality, and in particular, rules concerning appeals, because it would be wrong, I think you've just accepted, to interpret 3.17 as making appeals redundant.
Indeed, yes.
And it follows, I think you must also accept, that one must also interpret Rule 3.17 not only by reference to Part 52 as a generality, but specifically 5230.
Indeed, yes. But as I'll come to show you on the authorities, there are in face up to this, in exceptional circumstances, the court has power to vary final orders under 3.17.
Yeah. Can I just ask you this? The heading to this part of Part 3, and indeed the heading to 3.1, we start with case management, and then we go to the court's general powers of case management. What case are we managing?
Well, it's the action as a whole, and I mean maybe the answer I can become more apparent when I show you, Your Lordship, a couple of authorities, because what the authorities don't say is 3.17 is only about case management decisions. I mean, that might be a way that the authorities could have gone, and the way the rule could have been interpreted. That you say this is all about interim case management decisions, and final decisions are just out with this order. But that isn't the way the cases have gone. So can I go to the authorities bundle and to tab 6, and this is the case of Terry and BCS. And this is to deal with my other friend's first point, and also to acceptance, which is that Rule 3.17 only applies to final orders in exceptional circumstances, and I'll go on to explain why we say this is such a situation. So this was a decision of this court, and if we could pick it up at paragraph 68, which is on page JA 98.
Yeah.
And there the rules set out. And in paragraph 71 at the bottom, the White Book commentary draws a distinction between varying or revoking an interim order and a final order. And it refers to a final order as being an order which determines between the parties the issues which are subject to the litigation and which give rise to cause and action estoppel between them. And that, obviously, my Lord's final order after the appeal was a final order. And then, first of all, this is Lord Justice Amblin, deals with the case of Tibbles, which I'm sure you'll be very familiar with, which deals with interim orders expressly. And just to pick up a couple of points in relation to those, the circumstances, the generally accepted circumstances in which an interim order can be set aside are set out in little Roman 2 there, which is material change of circumstance, and where the facts on which the original decision were made were innocently or otherwise misstated. But another point that comes out of this is that the courts have been keen not to circumscribe all the situations in which this rule can apply, and we see that at the beginning of the paragraph. Then in paragraph 73, we come on to final orders, and perhaps your lordships and your ladyship could just read paragraph 73 and the quote from the route case to yourself rather than me reading it out.
So I'd like to ask a question which goes back to what I was asking before, and it's something that puzzles me, because something that's nowhere referred to except, as it seems to me, implicitly here, is the question we were talking about earlier. So the point that was made, I think, first by Mr. Justice Neuberger, that it can't constitute a power in a judge to hear an appeal from himself in respect of a final order, which was picked up in later authorities, is endorsed. The question is, well, why not? And I think you've accepted, but I want to be clear about this, that if we ask ourselves why not, despite the apparently open-ended nature of the rule, it must be because we're construing the rule in its overall context. And I'm going to avoid the use of Latin tags, since we're told not to use Latin. But this is an application of the principle that a general provision in a document will be excluded by a specific provision. So we have specific provisions in the CPR dealing with appeals in Part 52, and those therefore exclude the apparent generality of the rule in 3.17. Now, would you agree with that way of looking at it, or not?
Well, my lord, no, in the way that the authorities have gone, that it is clear that there is the power in exceptional circumstances for the court to vary or revoke its orders, even when those orders are final orders. Now, a point...
But 5230 allows that to be done, doesn't it?
Well, that allows appeals to be reopened.
Yeah.
And I mean, of course, in this case, we're not seeking to reopen the appeal in the sense of putting new evidence in, trying to have a further hearing. We're merely saying that the orders that your lordships made after your judgment on the appeal are ones that we say some of them certainly cannot stand in the light of the revocation. The orders for the declarations that the patent is valid and are accepted and so on. And other ones, including in particular the cost provisions, are ones that ought to be revisited and consideration given to whether they remain appropriate given what's happened in the parallel EPO proceedings. So it's not a reopening of the appeal in the same way as many of such applications that will come before this court. It's a simple reliance on a fact that's happened since then to set aside the order. Well, there's also another difference in this case, in that we still have an open application for permission to appeal to the Supreme Court. So this isn't a case.
Well, that may mean that we're no longer managing the case.
Well,
So you put it in the hands of the Supreme Court.
Well, it may do, my lord, and we could short-circuit it that way. But we felt it was appropriate to make an application, given what we were directed by the Supreme Court. My lords, ultimately, my submission is that had the TBA decision been given perhaps a month before the hearing of the appeal before your lordships and your ladyship, the right thing to have done in the light of the revocation of the patents would have been to come to this court and say, well, the patent's been revoked now, we need to set aside the orders of the judge, and that's the end of the case. So my submission is either that if that's what would have happened before the final order, it still remains the appropriate thing to do now, and we say that the rules do allow your lordships to do that, but the alternative is to say, well, actually, this case for the Court of Appeal is now over, it's still live in the Supreme Court, and that's where you need to go.
Is there any relevant distinction in this regard between a final order at first instance and a final order in the Court of Appeal?
Not that I can think of on my feet, my lord. No, I don't think there is. I think it's a final order is a final order.
And, well, specifically the County Court, which doesn't have the power under 5230.
But the High Court does.
Hmm?
But the High Court
The
does.
High Court
High Court does, but the County Court doesn't.
So 3.17, well, on any view, 5230 can't exclude any application of 3.17 in the County Court. But I would just finish off on the authority we were on. If we go to paragraph.
But before you do, is there any distinction or to be made between the substantive order for relief and the costs order in relation to whether 3.17 or 5230 applies? Could one say that actually 5230 might apply in relation to one but not the other? Is there any dichotomy there? Or even 3.17 might apply in relation to the substantive relief, but shouldn't be extended to the costs, which is a true reopening. Is there any distinction or none?
My lady, I don't think there is, because the costs, obviously, one of the primary factor in the costs when making cost of it is the substantive relief, and who's won and who hasn't, and the extent to which one party's won and one party's deprived them of the relief they sought. So I think it's very difficult to separate the two. And of course, all that.
Well, it might be said, and I think it has been suggested, though nobody's ever decided this, that 3.17 only applies an order made, quote, under these rules, unquote, and that declarations, for instance, are not made under these rules. They're made in exercise of the court's inherent jurisdiction, whereas the costs order may well be made under the rules. I mean, there may be a distinction there, I don't know.
Yes, and again, that's not a distinction that one sees in the authorities anywhere. If anyone's saying it's only sort of procedural type rules or those kind of things that are made under the rules, and so, for example, an injunction or a damages inquiry ordered under the Patents Act just doesn't apply.
Well, an injunction is statutory, so again, I suppose you might theoretically, at any rate, make the same distinction. An injunction is granted pursuant to statute in the case of a patent, because true it is that it's originally the power of the Court of Equity. It created the injunction as a remedy, so in that sense it's inherent. But underlying it is the statutory grant of the monopoly.
unfortunately, we don't have to worry ourselves with injunctions in this case because there isn't an injunction. It's damages, which is clearly something that's been ordered under the statutes.
Yeah.
May I just... Yes, well, I've been reminded that under CPR Rule 40.20, the court can make declarations under the CPR as well. It's not just inherent. So, what my submission is in relation to 3.17 and final orders is yes, they can be made in exceptional circumstances. There's no, again, similar to the interim position under interim orders, there's no exhaustive classification given. The courts have been careful to say that it's not circumscribed in any way. And in addition, the factors that apply to interim orders are not enough by themselves to justify varying a final order. So material change of circumstance and change of facts, although I would submit they still remain a relevant factor under it.
So exceptional circumstances. Is there any difference between exceptional circumstances for the purposes of 317 and exceptional circumstances for the purposes of 5230?
I think it's difficult to understand, difficult to construe or to interpret the same words to mean different things.
Well, you're not interpreting words in 3.17, you're glossing 3.17.
No, but I think
those words do appear in 5230. Is there any difference, do you say, between the tests that would apply?
No, I don't think so. I think exceptional circumstances means exceptional circumstances.
Sorry?
It means what it means exceptional circumstances in both contexts.
But can I ask you this? I mean, again, there may be a potential difference between first instance and appeal. But certainly if we concentrate to begin with on first instance order, you say, and I understand why, that there is support in the authorities for the proposition that, albeit only in exceptional circumstances, the court has power under 3.17 to set aside a final first instance order. But can you articulate any circumstances which might be regarded as sufficiently exceptional, given that fraud is not enough? We know that if you want to set aside a first instance order that have been obtained by fraud, you can't apply under 3.17, you have to bring a fresh action. So fraud is not an exceptional circumstance, so what is?
Well, my lord, I'm not sure that's quite right. Fraud is, I can show, my lord, well, it's in the context of the Interim case where Justice Marcus Smith refers to a decision of this court. It says fraud is enough, but fraud has to be proved. So what has to happen is you have to have a separate action.
Does that survive Thacker? I mean, I thought, doesn't Thacker establish that you have to do it by a fresh action?
You do have to do it by fresh action, my lord. The reason why is because obviously fraud has to be proved properly. But once fraud has been proved in the fresh action, then you can rely upon the judgment in that action to set aside the order obtained.
Well, that's because it's a judgment. But I think if the fraud is admitted, you can appeal on Ladd-Marshall type grounds.
On the basis of a new fact that
Yes.
you couldn't have known before because it hadn't been...
But if it's not admitted, then you've got to prove it in a fresh action.
Yes. But once it has been proved, then the previous order can be set aside.
But that's not because of the CPR, that's because of the law's attitude to fraud.
Yeah, I mean, the order is quashed by virtue of the subsequent order of the court finding that it was obtained by fraud.
Well, can I just take you to tab 7 of the bundle and just probably get it out of here. This is the first instance decision in Interim, but what the judge does in that is he goes through some of the authorities. And could we go to, it's paragraph 48 of that, where he's referring to the issue of final orders. and he refers to the case of Alsop and
48, yeah.
Banner Jones, which I think my Lord Justice Arnold and Lewison were in. Perhaps if you read the two paragraphs from the Alsop case to yourself, and it's in particular the second paragraph, paragraph 25.
Yes, but how does paragraph 25 relate to our situation? Because as was expressly said there, it's challenging that decision in other litigation. So it's a second action, and the second action will generally be on the ground of fraud, or it may be a second action, maybe between different parties in which the same issue arises.
Yes, but there still needs to be the order that was attained by fraud still needs to be dealt with in some way, so unless it's set aside.
But it's set aside as a result of the finding of fraud, surely.
But that has to be set aside under a power to do so.
It's the court's power by virtue of the finding in the second action. Why do you need 3.17? I don't understand how that enters into it.
Well, my Lord, the court has, unless it's under the court's inherent power, the court has to be acting under one of the rules in doing that. Right? Maybe it isn't ever expressed in terms of 3.17, but that is one way in which it could be done.
So just imagine this scenario. A claim is brought, and let's suppose it succeeds. It is then appealed to the Court of Appeal, and the appeal is dismissed. It is then discovered that the original judgment was obtained by fraud, and an action is begun in the county court, which has the power to entertain such an action, to set aside the Court of Appeal judgment on the ground of fraud. And that happens. You say that's an exercise by the county court of 3.17 to set aside an order of this court?
Maybe, my Lord, but maybe we've gone away from where we need to be for the purposes of this appeal.
Well, but is that correct? Because you're invoking 3.17, and our questions are directed to the issue which becomes front and centre on 3.17 as to the circumstances in which that power may be used to set aside a final order. And your submission, and it receives some support from the authorities, is that can be done, albeit only in exceptional circumstances. So what we're trying to work out is, well, what amounts to exceptional circumstances if it be the case, as we're suggesting, that fraud is not enough?
Well, so I mean, I'll deal with why we say this is exceptional circumstance, and that's because of the parallel jurisdiction between the national court and the EPO in relation to opposition proceedings and revocation proceedings, and it's inherent in that system that you get two cases going on at the same time between the same parties or the same undertakings, and that can cause, you can get conflicting decisions.
But there's nothing exceptional about it. It's inherent in the design of the system, because although, as I was saying earlier, it wasn't the intention of the framers of the EPC, nevertheless, the system they designed allows for this to happen, and we've known this now for decades. So there's nothing exceptional, actually. It's inherent.
Well, it's inherent, but it's a situation that doesn't arise very often. And I think in the 25 years that I've been practicing, the only cases where this has come before the courts are Unilin, Virgin, and Interim, and now this one. So it's 4 times in quite a long time now. So it's not something that happens regularly or frequently. It is an occasional circumstance that's particularly limited to patents, first and foremost. Doesn't have any wider application than that. And it's limited in the context of patents where there is parallel litigation or parallel proceedings in the EPO and the national courts, which isn't every case, and it's a rare occurrence that happens. So that's why we say it is an exceptional circumstance. Yes. So if I can just deal with them briefly before moving on to why we say that the court should exercise the discretion in this case. My learned friend's second point, which he relies upon the authority at tab 9, which is the Kerry digging and recycling case, say that 3.17 can't be relied upon to circumvent 5230. And perhaps we can pick this up at paragraph 19, just to get the background. What had happened in this case was there had been an application for permission to appeal, had been refused, and then there was an application to reopen permission on the grounds that the refusal of permission was wrong. Obviously a challenging application. And then paragraph 41, in the discussion, it says, ingeniously Mr. Adams' submissions were, they proceeded on the fundamental misapprehension that the court has an inherent jurisdiction to review a decision by a single lord or lady justice to refuse permission if the issue raised on the appeal was an arguable one, so the decision to refuse permission was wrong. And then there's reference that the proposed jurisdiction would be completely contrary to 5230 and 1, which makes it clear that it's only if the criteria set out in that rule are satisfied that the Court of Appeal will reopen the refusal for permission to appeal. And then in the next paragraph, contrary to Mr. Adams' submission, the jurisdiction which he contends cannot be derived, nor does it receive any support from the power given in CPR 3.17, and then it refers to Tibbles and the 2 well-known circumstances from Tibbles. And at the end of the paragraph, Mr. Adams hadn't addressed this principle in his opening submissions and really had no answer in reply to the point made by the court that he couldn't bring his case within it. In other words, 3.17 will not avail the first defendant, and any application to reopen can only be made under 5230. So what we say this case establishes is that if you can't bring yourself within 3.17 or 5230, then there are no routes available. But what it doesn't say is that 5230 excludes all applications under 3.17.
Sorry, why is that not what is said in 43? In other words, Rule 3.17 will not avail the first defendant, and any application to reopen the appeal can only be made under 5230.
We won't avail him because, as they held in the previous paragraph, the first defendant in this case couldn't bring themselves within 3.17 because they couldn't rely upon, they couldn't show a material change of circumstance, and they couldn't show that the facts on which the decision was based had been misstated. So because they couldn't bring themselves within those two established criteria for 3.17, they couldn't rely upon it, and only 5230 could have applied in that case.
In 42, he says, in the first sentence, the jurisdiction for which he intends cannot be derived, nor does it receive any support from the power given in 3.17. So he's considering it as a matter of jurisdiction, isn't he?
Yes, because the application that was being made was under some inherent jurisdiction. So council's submission in 41, there was some inherent jurisdiction to review, and that's in my submission the jurisdiction that's being referred to in 42. It's fair to say, Arnold, I think some of the authorities on this point don't all point in entirely the same direction.
Sorry?
Some of the authorities on this point don't all point in entirely the same
just
direction.
Coming back to what you said, I mean, it's helpful to look at what the submission was, which is recorded at paragraph 23. So there it's said, in spirit and bold submissions, Mr. Adams, on behalf of the defendant, focused not so much on 5230 as on what he submitted was the inherent jurisdiction of this court to review the decision of Lord Justice Popwell as recognised by CPR 3.17, which he submitted gave the court power to vary or revoke the order. So while you're right to say that he was saying there was an inherent jurisdiction, but he also saying it was recognised by 3.17. So he was relying upon 3.17, and the answer given is, well, no, you can't rely upon 3.17 to circumvent 5230.
Well, in my submission, what the decision was in 42 was you can't rely upon 3.17 because you can't bring yourself within the two criteria from Tibbles.
Can I just ask you about ACRAM and the Secretary of State, which is referred to at paragraph 33, where Lord Justice Higginbottom is quoted, and he quotes 5230, and then he says, unless each of these criteria is satisfied, the court has no power to open an appeal. On the face of it, seems pretty unequivocal, doesn't it?
Well, it does, but my submission is the one I've already made, is when one looks at what the authorities have said on 3.17, is the answer isn't, well, 5230 or 5217 as it used to be called is the answer, that's it. It's there are limited circumstances when you can rely upon it. And this is where I come back to the submission that there may be a difference between reopening an appeal in the sense of opening it to re-argue it on the grounds of new evidence or something like that, and merely setting an order aside on the basis of an uncontrovertible fact, i.e. the revocation of the patent by the EPO.
And therefore you distinguish this case particularly because of that. It was inherently a 5230 case. It was seeking to reopen an appeal, and that's not your territory.
No. So, what I'd like to do now is move on to the second issue, which is should the order be set aside?
So just pause a minute. In Rout, there was an uncontroverted subsequent fact, namely that the boy was taken away from the home which had been, everybody thought he was going to live in, and on the basis of which his damages had been calculated. And the parents came back with some more, and they were told no. One can also envisage, can one not, a situation where somebody is awarded damages on the basis of an expected life expectancy, but they die early or fall under a bus, uncontroverted subsequent fact. You would say that 3.17 enables you to come back to court and say, well, look, here is an uncontroverted subsequent fact. You should now undo the damages order that you made.
Well, only if it would be appropriate to do so. I mean, in Rout, the order for damages would, sorry, in a life expectancy case, the award will factor in the likely prospect of the the defendant living for any period of time and the uncertainty of life expectancy. And that's factored into the award. So that would be taken
But
into
not
account.
being knocked down by a bus, as my law puts it.
Well, I
And
think
this happens actually quite regularly, because personal injury damages are regularly awarded in the courts in this country, based on the multiplier, which will be an actuarial assessment of life expectancy. But the actuarial expectancy doesn't allow for accidents. The bolt of lightning.
Yes, my juniors reminded me an important fact that, of course, although the revocation of the patent was subsequent to your lordship's judgment and order, it does take effect ab initio.
Retrospectively. Yes, yes.
So
Section
the
77
patent
says that.
is deemed never to have existed.
Yeah.
And of course, the poor defendant in struck down by a bolt of lightning did exist until the moment in which they were struck down by the bolt of lightning. There's a distinction between the two there.
But the assumption underlying the court's order has still been falsified by subsequent events, because the assumption is that on an actuarial basis, the claimant is going to live X years, and in fact, they don't live anything like X years because of a supervening event.
Yes, well, it's a different situation.
But nobody's ever suggested that the defendant can go back to court to say, oh, well, my claimant's been struck down by lightning, therefore please let me off 90% of the damages that I've had to pay.
No, but the defendant, of course, in that case, has still been negligent, and it was still appropriate for the compensation to have been paid.
Appropriate for it to be paid at the level it was whilst the person was alive,
Yeah.
on the basis of the actuarial assumptions. That payment has come to an end because of the bolt of lightning, but that doesn't mean that the previous payments were wrong.
No.
Whereas you say here, everything is struck out, is scored out, never existed.
Yes, the patent never existed. So at the moment, we have an order granting declarations as to essentiality and validity of a patent that is now deemed never to have existed. And we say that leaving those orders they should be set aside. And the cost order comes within that. Now, of course, I don't go as far as to say that every time a patent is revoked by the TBA or the European Patent Office in circumstances such as this, there's an automatic result about the cost order. Obviously, I have to persuade you that it's the appropriate order in all the circumstances as well. But what I do say is when there is a subsequent revocation, it does give the power to the court, you say under 3.17, to set aside the order and to consider whether they should be set aside.
Yes, I mean, it's not just a subsequent revocation, it's a subsequent revocation with retrospective effect.
So if I can turn then to the issue of what should be done in this case, and what I'd like to do is do that firstly by
I'm sorry, I'm just trying to work this one out. I'm just thinking that if there are other circumstances in which something like this has retrospective effect, and if a company is dissolved and then restored to the register, that has retrospective effect, and it is deemed to have continued in existence throughout the period of dissolution. But that doesn't undo what's happened in the meantime. So, for instance, in one recent case, company is dissolved. That's an event of default under a contract. The counterparty terminates the contract. The company is then restored to the register, deemed to have existed throughout the dissolution, but nonetheless the contract remained terminated. That happened.
but the contract that would have been freely entered into between the parties
So-
would be, in the event of a dissolution, then the contract is terminated, and that would presumably include circumstances in which it was dissolved and then subsequently reinstated. And if the contract might have provided for that eventuality, it obviously didn't.
It will be the dissolution process in the first place which triggers the provision.
Yes. So if we can go to tab 7 of the authorities bundle, which is the Interim case, and I'll go a certain way through the first instance judgment, and then I'll move on to this court's judgment. Now, this was a case where there'd been a trial first instance, and the patent had been found to be valid and infringed, and the judge had made the usual substantive orders consequent on the finding of infringement, and he'd made those at a hearing. But before the orders had been drawn up, the Technical Board of Appeal revoked the patent. And what the judge did, of his own motion, is he set aside the orders for substantive relief, and he then there was then a hearing as to what to do. And as we shall see, what the judge concluded was he changed the cost order from a cost order giving essentially the patentee all his costs, having succeeded at trial before him, to an order giving the defendants all their costs because they had been the successful party overall, because they'd secured revocation at the EPO. Now, that was then appealed to this court, which overturned the cost order, but only to the extent of replacing an order for the defendant's costs with no orders for costs, because the court held that it was the parties' joint fault, that the court hadn't been kept in the loop about when the TBA proceedings were happening, and it was both their faults that the costs had effectively been wasted before the judge. So, could we go to paragraph 38 of this judgment? And
Can you give me a page? You have
yes, sorry,
very
it's
long
JA
paragraphs.
123.
122.
123, sorry.
123. Yeah.
And what the judge first considers is jurisdiction to vary his order. Now, of course, those were final orders, but the difference between that case and this one is they hadn't been sealed.
Yeah, but not only that, the whole thing went off on a slightly false basis, because although Re-L is mentioned in footnote 26 on this page, that doesn't quite seem to have been given the effect it might have done, because it was common ground that there had to be a material change in circumstances, which is not what Re-L says.
No, that's it. It is a the outsider model. This is a conundrum about the Court of Appeal decision as to why material change of circumstance was the battleground.
Well, I was very careful to say I was going to assume that that was correct, although the contrary was arguable, for the reason I've just given.
Yes. So, but what happened, if we go over to paragraph 40, the judge refers in 41 and 42 to Barrel and then Re-L. And then in 43, we can see that the submissions were focused on 3.17 and not on Re-L. And the judge then went through the authorities that we've looked at. So first of all, Tibbles in relation to interim orders. And then if we go over to paragraph 48 on page 126, it's the paragraph we've already looked at about final orders. And in 49 on page 127, the judge says that the claimant's point is the December 16th orders, those were the original orders granting relief essentially to the patentee. Final orders, and then none of the criteria, and he lists the three for interim orders and then fraud and new facts for final orders don't exist, which he agrees with in 50. But he goes on later in paragraph 50 to accept that it was an exceptional case even among exceptional cases. The knowledge of both leading counsel hadn't arisen, and that shouldn't prevent him from revisiting it. And the judge agrees with that there's a jurisdiction and that his discretion, he should exercise that discretion for a number of grounds, which he sets over a number of pages. And if I can just try and summarise those. The first one in subparagraph 1 is the parallel jurisdiction point, which obviously we have here as well. He then, over quite a long subparagraph 2, refers to the authorities on stays pending the EPO, the practice summarised in the judgment of this court in IPCom and HTC, and which ends up on page 131 with the guidance given by this court. And in particular in 4, the inherency of the possibility of concurrent proceedings, and in 7, particularly in 7 over the page, if allowing the National Court to proceed might allow a patentee to obtain monetary compensation which is not repairable if the patent subsequently revoked, will be a weighty factor in favour of grant of a stay. It may, however, be possible to mitigate the effect of this by offer of suitable undertakings. And then in paragraph sub 4, at the bottom of page 132, the judge rejects the submission that the two proceedings are separate. He says that, well, the bottom, 3 lines on the bottom, he rejects the submission they cannot be revisited because they're separate and distinct. They are separate and distinct, but does not mean they don't interrelate and not interconnected. They obviously do. And then I think in 6, I need to draw this to your Lordship's attention, he says it doesn't inevitably entitle a party to go back to the trial judge and ask him or her to review the prior order. All I'm saying is such determinations can, but need not necessarily justify such a review. And he then goes on to give an example of what would have happened if in that case the TBA hearing had taken place when it ought to have taken place without expedition, which would have been about 18 months hence. And he says in that case he would have been hesitant about using 3.17, but would have considered the most appropriate course would have been for the orders to be appealed to the Court of Appeal and the Court of Appeal to give guidance. Now, that's obviously a pragmatic response to or answer, but of course it's not a principled one. It's not one that we found in the rules anywhere. And in my submission, the time between the final order and the subsequent EPO decision revoking the patent is merely a factor that can be taken into account. But of course, in this case, we applied to the Supreme Court within, I think it was from July to November, so it was a relatively short period of time after the final order of this court. And then I think over to page 134, in 8, the judge refers to the orders that he made regarding delivery up and destruction. They demonstrate, in the judge's view, the clearest possible way that the error in the patentee suggestion that the cost order can't be revisited, and that's because those orders for delivery up and destruction couldn't stand in the light of the revocation of the patent by the Court of Appeal, and indeed the patentee in that case didn't even resist the setting aside of those orders. And then in 9, the judge then goes on to consider the costs order, and he sets out the factors which are material to him in that case.
So how does this help you, given that this court took a different view?
Well, this court took a different view not on whether the order could be revisited, but whether it should be and what it should be revised to.
Well, there was no doubt that it could be revisited because the order had never been sealed. So there was plainly jurisdiction to revisit it, and indeed the contrary wasn't argued. There was no suggestion, either at first instance or on appeal, that there was no jurisdiction in the court. The question was, upon what basis could the jurisdiction be exercised? And it was essentially common ground, certainly it was common ground in this court, that there was a threshold that had to be got over of a material change in circumstances. But if there was a material change in circumstance, it wasn't disputed there was jurisdiction.
Yes. So, just to be clear, at the moment I'm on the point of how should the jurisdiction be exercised in this case. I'm not relying on Interim in relation to the existence.
Yes, but on how the jurisdiction should be exercised, this court took a different view.
Yes, well, yeah, but I'm coming to the discourse decision, which is obviously the important one, but one needs a bit of the background because Interim was tortuous even by patent case standards. I'm trying not to just jump straight into the middle of it. So maybe with that we can turn to this court's decision.
Sorry, can I just ask about this order? Subparagraph 8, which you referred us to on page 134, talks about the delivery up order. And I assume that was an order for delivery up of the infringing products. I suppose that part of the order had been complied with, and the infringing products were delivered up or destroyed. What then happens? You set it aside and compensate the alleged infringer for having destroyed the pharmaceuticals in question? How does it work?
The easy answer to that particular problem on this case would be that it's standard that the court, pending appeal, would stay in order for delivery up and destruction for precisely that reason, that order then can't be undone if the Court of Appeal overturns the...
Well, I follow that, but that's a procedural mechanism, rather like a stay, pending the outcome of proceedings in the opposition proceedings in the EPO. But what if it's not done? And follow the things the court could do. Suppose it didn't. Nobody asked it to. The delivery up order was made. The products were delivered up and destroyed, and then the court wants to do something. Well, what's it going to do?
Well, it may be that if all routes, if the liability phase of the proceedings in a patent case, one does liability first and then comes back and has a damages inquiry. If that's over and all routes of appeal are finished and the infringing products have been delivered up and destroyed, it may be that there is nothing that can be done thereafter because that order has been complied with. And that's
the inquiry is ongoing. As we know from Virgin, you can rely on the revocation in the inquiry.
Yes. Virgin wants to be a bit careful with Virgin because in Virgin there had been a substantive appeal in the Court of Appeal. There had been an application for permission to appeal to the Supreme Court, which had been refused. And then the applications then ended back up in the Supreme Court, were in the inquiry. And that's why Lord Sumption in the Supreme Court said that the findings of validity and infringement were res judicata between the parties because the liability phase of the proceedings were completely over. We're not in that stage in this case because we're still with pending appeals open to the Supreme Court. And of course, your Lordship's judgment doesn't create a res judicata against yourself to do something in these proceedings because this is just part of the appeal proceedings, albeit I've come back a period of time after final order. So it may be different. It might have been different if time had gone on sufficiently that all the liability part of the proceedings were over. But we're not in that position in this case. So if we can turn to tab 10 of the bundle and go to paragraph 40 on page JA 203.
Sorry, J2.
203.
Thank you.
So this is again, picking up what the judge did, but it's more convenient from this court's judgment. So in 40, this is my Lord Justice Arnold notes that the judge started, as is traditional, by considering the question of who was the winner. And prior to the EPO decision, the judge had concluded, and obviously so, that it was the claimants who were the successful parties, save for one issue on an exclusive license. And then after the revocation, he said, viewed as a matter from the point of outcome, it's obvious that the defendant is now the successful party and the patentee is the loser. And he concludes that given because of the interaction between the EPO proceedings and the proceedings in these courts. And what the judge then went on to do was to completely reverse the cost order and make the patentee, who had succeeded in almost exclusively in front of the judge, pay all the costs of the action. So if we turn on to paragraph 45 on page 206, there's the grounds of appeal set out. And the first one was he was wrong to conclude that the defendant, Milan, was their success means they were a successful party in the English proceedings. 2 is the ground the judge should not have reversed his previous cost order. And then 3, he should have done an issue-based order. So after a few paragraphs on cost appeals, ground 2 was dealt with first in paragraph 48. As my Lord Justice Arnold noted a moment ago, in 48, the claimants didn't dispute that the judge had jurisdiction to reconsider his order in light of the relevant revocation, but contended there'd been no material change of circumstance. And that submission was rejected. It was held that the revocation was a material change of circumstance. That's paragraph 49.
Assuming, as I was careful to say, that the premise was correct.
In particular, the court referred to issues of timing and what would have happened as if the revocation had taken place during the trial or after the trial before judgments had been handed.
Where are you?
51. Sorry, my lord. Perhaps if my lords and my lady could read 51 and 52,
yeah.
I'll make some submissions on those.
Yes.
So in relation to 52, just some submissions. Firstly, the revocation of the patent is as much a material change of circumstance in this case as in Urim, and then we say that remains a factor. We rely upon the timing point as well, and as I submitted a moment ago, if the revocation by the TBA in this case had happened a week before the appeal had been heard before your lordships and ladyship, the correct approach would have been to set aside the orders of the judge and potentially consider what to do in relation to the costs.
I'm a little puzzled as to why you say timing doesn't matter when you've just cited a paragraph saying that timing is crucial if you're after the sealing of the order.
Well, I'm just coming on to address that point next, my lord. But certainly, insofar as the revocation had taken place before the appeal, then the correct approach would have been to discharge the judge's order in the light of the revocation, and that would have remained the right
from this court.
From this court, yes. And that would have remained the right thing to do, even if the court had handed down judgment and had made an order that hadn't been sealed. The question is, does the sealing of the order make a difference? And
But Nurin was a straightforward real.
it was, although before the judge it appeared to have been argued primarily under 317. The reason why I haven't relied on it in support of the jurisdiction under 317 is because it was plainly fell within the real jurisdiction as well, and therefore whatever the judge said on 317 was obiter. But turning back to the issue of whether the sealing matters, two points. Firstly, obviously 3.17 is not expressed in terms of anything to do with the sealing of the order. And secondly, in Riel itself, Baroness Hale refers to the relevance of the sealing. I'd just like to show you just a couple of paragraphs in that. So that's the next tab 11 of the bottom. And this was a child case, a child care case, which one always has to keep in mind. And it was the issue, as I'm sure my lord and my lady are aware, was whether exceptional circumstances were required under the inherent jurisdiction. And this was the case where the Supreme Court said no. But if we go to paragraph 32, which is at the bottom of page 223, there's a section that's headed, but what if the order had been sealed?
And I assume you would accept that this is all obiter.
Yes.
Yeah.
And then Baroness Hale goes on to deal with issues that arise only in care cases, which obviously I can't rely upon in this case. But perhaps my lord and my lady could read paragraphs 37 and 38, where there's some more general principles.
So this, just remind me, Riel was a fact-finding hearing in a child case.
Yes.
The judge heard the evidence, announced her decision, and then changed her mind.
Yes, and it was specifically a case about judges changing their mind and saying,
yeah,
I got it wrong.
In
And
circumstances where the order hadn't been sealed.
When it hadn't been sealed.
And the fact-finding part of the case was the prelude to the ultimate welfare decision. Because the welfare decision has to be made on found facts.
Yes.
So the case as a whole was still progressing towards its ultimate conclusion.
Yes.
And I think we can see that from, for instance, paragraph 34. Because these were care proceedings. As then Baroness Hale explains in 35. Right, you wanted us to go to
37 and 38.
37.
And it's really only the first half of 38.
But would you accept that, given that the order had not been sealed, which is why this passage is obiter, it's likely that the Supreme Court didn't receive any argument on how 3.17 should be exercised, or whether it was applicable if the order had been sealed? And none of the relevant authorities are referred to, are they?
No, well, it is an obiter comment.
Well, it's not just that it's obiter without the benefit of adversarial argument and without the benefit of relevant citation of authority. Do you dispute that?
Well, no, my lord, it is what it is.
Right.
But it is, it is from the Supreme Court. So.
Yes, quite so.
One step forward, one step back. But we do say that the principle in those paragraphs is a sound one, that if there are good reasons to set aside the order to revoke it, then the sealing of the order shouldn't be a magic end stop date if it remains appropriate to do it. And then the last point I wanted to address, if we go back to Interim and back to paragraph 52, so that's tab 10 and page 208. And the last point that my Lord Justice Arnold left out was whether the position of party in the position of Milan would have some other remedy if the final order was sealed before the patent was revoked. Now, usually what that is a reference to undue enrichment or potential for restitutionary claim. And what we've put in the authorities bundle in tab 13 is the relevant section on Goff and Jones and one of the authorities it refers to. If I can just make a submission based on that. Really, one can get it from the first paragraph of this chapter of Goff and Jones, that there is no prospect of an unsuccessful party recovering whatever they've had to pay under the court order as long as the court order subsists.
What would you say to the following suggestion? I emphasise the word suggestion. That the proper remedy for any party in the position of your client is a claim for unjust enrichment, insofar as existing English law does not accept that it's a matter to be rectified by a decision either of this court or, if necessary, the Supreme Court. But it requires a fresh action. Because, as you may know, this is how the civil law deals with these problems. It's dealt with through the prism of unjust enrichment, restitutionary claims. In fresh proceedings, you bring a fresh claim for restitution of that which you say you have been unjustly deprived of. Now, of course, different laws take different views as to what amounts to unjust enrichment, which is, and hence, and as you're showing, it's currently English law is against that. But it's a common law rule, so it's not immutable.
Yes. So, obviously, Manuel, that may deal with the costs order side of it, and obviously the focus of the submissions this morning is primarily on the cost order.
Well, it's particularly relevant in this case because here you're not merely trying to set aside an order. Actually, what you really want, above all else, is repayment of the money you've actually paid, which is quite striking. It's not just that you would say, well, that order that the Court of Appeal made, we can now see with the benefit of hindsight was wrongly made because the patent's been revoked ab initio. You're saying, and we want the money we've actually paid to be paid back to us.
Yes.
Now, why is that not classical claim for unjust enrichment?
Well, that is, but of course, the hurdle to doing that is to set the court order aside. So when my lords on an ordinary appeal allow an appeal and overturn the judge below and overturn the costs order, the power that you exercise to order the cost to be repaid is a restitutionary power. It's a restitutionary claim. But the court needs to set aside the order below because until that's done, the money's being paid over by order of the court, and it's not been unjustly enriched. They've been justly compensated.
Yeah. Well, can I ask you this question, which seems to be implicit in what you've just submitted? Do you accept, therefore, that even if you are successful in obtaining a setting aside of our previous order, that in itself would not entitle you to repayment of the costs paid? You would have to bring a claim for unjust enrichment as well.
No, my lords could do it in this action, in the way you would do if you'd set the order aside, the judge's order aside in the course of an ordinary appeal.
But it's not an ordinary appeal. It's a final order which has been set aside subsequently.
Well,
But the money's already been paid. So you say you don't need a second action for unjust enrichment. But the mere setting aside of the order is not enough.
no.
You have to have more.
Yeah.
At minimum, you have to have a positive order of this court, or whichever court is making the order. You need a positive order requiring IPCom to pay you that money back.
Yes. Well, and we would say that order would follow from the fact that the order that was made, the order that ordered the cost to be paid, has now been set aside. Therefore, there's no proper basis for that money to have been paid. And it then follows that this court then can order repayment.
Yeah.
And that one follows from the other like night follows day.
Indeed. So just to finish off on Neurim, I'm conscious of the time, but I'm nearly there. In Neurim, what happened in the Court of Appeal is that the judge's order that the defendants get all their costs was set aside and replaced with an order for no orders to costs, because it was accepted that both parties were to blame for the wasted costs of the trial having taken place. But what was upheld, and I probably should just show you this, was if we go back to Neurim, so that's tab 10, and go to paragraph 53, which is on page 208. And the first sub-point in ground one was the judge was wrong to treat Milan's success in the EPO as determinative of the question of who was the successful parties. And the second was that even if the judge was right to conclude that they were the successful party, he was wrong to treat that as determinative of the instance of costs. So in 54, our Lord Justice Arnold rejected that first submission and held that the judge was correct to say that the subsequent revocation was conclusive as to who were the successful parties in the litigation. But then went on to find that the fact that they were the successful parties wasn't determinative of the cost of the action, and all circumstances had to be considered. And then what then happened was then the order was replaced with no orders for cost. So if I can just then draw together submissions why we say it's appropriate to set aside the order in this case. I think I've got 9 or 10 points, but they're quite crisp ones. The first one is the existence of the parallel jurisdiction, and the fact that Vodafone entities were parties in both those jurisdictions. Second one is that the outcome of the EPO means that the patent is deemed never to have existed. IPCom never had a patent on which they could rely and seek remedies from Vodafone, and this court's order, and the order of the judge insofar as it stands, grants relief on a patent that has never existed. Third point is the point I've made several times already about not requiring a rehearing of the appeal. It's based on the fact of the revocation. The fourth point is that these are exceptional circumstances for the reasons that I've already explained, that it's limited to patents that are in parallel litigation in the EPO and the English courts, and it's a rare occurrence. The fifth point is that the result in the EPO is, insofar as it's relevant, a material change of circumstances. We saw that from Neurim. And it is determinative of the question as who was the successful parties in the proceedings. It was Vodafone and not IPCom. But I accept that in itself isn't determinative of the question of the costs order. But sixth point, what Interim does show is that in rare situations like this, the court doesn't just say, well, you fought issues in the English court, you lost issues in the English court, and the result in the EPO has no impact on the cost position. The interrelatedness of the two sets of proceedings does have an impact. The seventh point is that in Interim, the judge put the cost risks, the trial judge put the cost risks on the patentee as the party bringing the proceedings in the knowledge of the parallel EPO proceedings. And this court held that he was wrong to do that, and that the determining factor was the fact that both parties were to blame in not keeping this court informed of the TBA appeal.
Sorry, say that again. Both parties were at fault in not keeping the court informed.
Yes, because the judge wasn't. He'd been told about the existence of the EPO proceedings, but wasn't told that they'd been expedited to be heard very shortly after his trial, and that was a plague on both your houses, and hence no order. Now, no such factors are at play here. What happened, as I explained at the outset, is that Vodafone, we made an application for stay at first instance, and suggested that the appeal be delayed until after the EPO. But at IPCom's insistence, the case was expedited. And the reason for that expedition was to get a judgment out before the patent expired. But as Mr. Justice Burse held when he expedited the case, those time pressures were largely of IPCom's own making because of its delaying commencing proceedings. So having sought expedition for its own benefit, we say it shouldn't avoid the consequences of expedition now that the circumstances that we'd warned about have come to pass. And as in Interim, it transpires that the costs of the proceedings in this jurisdiction have been wasted. It needn't have happened. But that's solely down to IPCom wanting to push on the proceedings and effectively resubmit, taking on the cost risk itself. Now, I've already dealt with my friend's point about, well, you didn't actually orally advance the arguments for the stay in front of the trial judge. And my answer is the one I gave earlier, which is it wouldn't have made a difference because the judge was going to expedite it anyway, and he plainly knew about the appeal, the opposition proceedings. My eighth point is the timing point, which is the point of what would have happened had the EPO been before the judgment. And we said that shouldn't make a difference that it happens now. And the final point is the lack of any alternative remedy, absent setting aside the court's order. And then, I think before finally just...
Can I just ask you about your ninth point? Do you say that the mere fact that you have applied to the Supreme Court for permission to appeal removes this court's jurisdiction under 5230?
That is not... Well, we say that the reason why 5230 doesn't apply is because there is an alternative remedy, which is the appeal to the Supreme Court. Now, my Lord may be referring to some of the comments in Taylor and Lawrence, where they said that this court can take a view as to the...
Is the prospect of appeal theoretical or real, is what the court said in Taylor and Lawrence.
Yes. Well, I think, my Lord...
Is there a spectrum of cases? In some cases, this court can say, well, yes, you've applied for permission to appeal to the Supreme Court, but your appeal is all on the facts, there are concurrent findings, you're never going to get permission, we are therefore the final court. And other cases in which the court can say, well, although we're not giving permission, we think it highly likely the Supreme Court will take this case, and then somewhere in the middle.
Yes, and on this one, what I would say, my Lord, is firstly, the Supreme Court obviously had the opportunity to say no already. They could have looked at it and said, well, that's just too bad, too late, and this is not something for us, and they could have refused permission. But they've expressly...
Well, they have adjourned your application to amend. They haven't given you permission to amend and then considered the amended application. But it's also right to say they have not dismissed your original application based on Crown use, although in answer to my lord, you accepted that you wouldn't get permission on that because it's all academic.
Yes.
So,
but the only point I make is that they could have dealt with the amendment application and permission to appeal all in one go and just said no, and they've expressly not done that. So that's the first point, and then the second point is comes back to the nature of the point that we seek to make, which is we won't be actually asking the Supreme Court to deal with a substantive issue. It's the issue that arises from the relief given the fact of the revocation.
all right. Another question, again, along the same sort of lines. If the Supreme Court were to refuse permission to appeal, do you say that our jurisdiction under 5230 would then reappear, arise, or what?
I think my submission is that it would. The reason why 5230, why we say it doesn't apply, is because of the availability of an alternative remedy at the moment, which is the appeal to the Supreme Court. Then, if that door gets shut,
You can come back.
we can come back. Or am I just... Yes. And although my learned junior is keen for me to point out that obviously the reason why we're here is because that was the suggestion of the Supreme Court.
Well, the Supreme Court said you must think about it. Don't think it said more than that.
The last point, well, my learned friend's second overarching point is we should have got, after trial, we should have got an order perhaps giving liberty to apply to vary the costs order in the event that the patent was revoked in the EPO. And it's obviously correct that we didn't do that. But my submission is really that's not really a point for him, it's a point against him, because had we asked for liberty to apply in the event that the outcome of the TBA hearing was the patent was revoked, it's difficult to think of any principled reasons why that liberty to apply wouldn't have been given. And if that's...
So, can I be clear? You're accepting it would have been given?
Well, yes. There would be...
So, why is it not your fault that you didn't ask? You accept that something was on the table to be asked for, and it would have been given, but you didn't ask.
Well, no. But what we say is that because liberty to apply only gives a party liberty to apply, it's likely that it may well have been given. Difficult to see why it could have been argued against. And in those circumstances, we say it's difficult then to say why it shouldn't be reconsidered now.
Well, because I'm going to phrase this in a way which is not entirely apposite, but just to make the point, it's Henderson abusive process. I mean, it's not truly apposite because we're talking here about procedural. But the point is, you could and should have asked then. Not having asked then, it's too late to try and unwind it now.
Well, also, it's an order in that form is an order which expressly contemplates the possibility of variation in a particular contingency, unlike a final order which doesn't.
No, but our position is...
In other words, the liberty to apply means it's not as final as a final order.
No, it's left over for that purpose.
Yes.
But I also might have my submission that if that was an appropriate order to have made then it becomes equally appropriate to reconsider it now.
But can I just press you slightly more on this? Because you made the analogy earlier, which I think at the moment is a very apposite analogy, if I may say so, with what happens in the ordinary case pending appeal. So in the ordinary case pending appeal, you get an injunction, delivery up, assuming obviously the patent has been successful. And it stayed pending appeal, usually on terms as to a cross undertaking, and then you can get in debates as to, in some cases, whether an injunction should be granted or not. And so you get into all of that question. But the starting point point is that the substantive relief will usually be stayed, and conversely, if the patent is revoked, again, it's stayed pending appeal. So this is basically routine. So what's the difference here? Because the point of the stay is to allow for the possibility that the first instance court is wrong, Court of Appeal takes a different view thereafter, and therefore the order that's been made turns out not to be the right order. Revocation by the EPO is an exactly parallel circumstance. It turns out that the relief that was granted ought not to be granted because the patent never existed, thanks to the EPO. Why is there not an exact parallel?
Well, because what the position is this court has in our submission still the ability to put right that which shouldn't have happened. And it's different from a situation that may arise, which is if a patent is revoked at first instance by the English courts, and then that order for revocation isn't stayed, there's then the question mark as to whether the Patent Office are ever able to undo a patent they've already revoked, which is why it's always stayed pending appeal in that eventuality. I think the one final thing I probably ought to do is to show you the actual orders that we've been asking you to set aside. We've obviously been focusing on the cost side of it, but there are some other ones.
Yeah.
Probably right to be looking at. So that's the core bundle tab 7. And this is the order of the judge. And the relevant orders, we start with paragraph 1 on the second page of the order, which is a declaration that the claims 1 and 7 of the patents are essential to various paragraphs of a particular mobile phone standard. And we say that in the light of the revocation of the patent, that can't and shouldn't stand.
But do you need that set aside, given it plainly has no effect, given the patent no longer exists?
Well,
is deemed never to exist.
For practical purposes, no, but we say it follows on in the same principle. Let me just go through the rest of the orders and briefly show you the ones that we say should go. Next one is paragraph 2, which is a finding of infringement.
Mm-hmm.
Again, same reason patent's gone. Then 3 and 6 were set aside by your lordships and your ladyship. 4 and 5 declarations of non-infringement. I think it's neither here nor there what happens to those. Then over the page.
But again, I mean, if we're going into this level of detail, you say, well, it doesn't matter if 4 and 5 are set aside or not, but they're meaningless. You know, a declaration of non-infringement in respect of a non-existent patent is completely meaningless.
So, page 4, we then get the orders at 10 and 11 and 12 and 13 for the inquiry, and we say that they should go. And then,
Well, can I ask you this? This is an interesting point. Is there any contest on paragraph 10? Because what we know from Virgin and Zodiac is that if there were to be an inquiry, you can set up revocation of the patent and say damages are 0, or at any rate nominal.
yes,
But is there actually any dispute about paragraph 10?
my learned friend hasn't addressed it. I think it follows from his submissions that he is disputing that your lordships can do anything. But we'll have to hear what he says on that.
Well, no. The order would stand, but there would be no inquiry. Is the point?
Well, yes. So, but to that extent, these orders standing, we raised the revocation as a defence, and that would be the end of the inquiry.
Yeah. But sorry, what I'm trying to get to is the question of whether there's any real dispute about paragraph 10.
Although they ought not to be, because Virgin ought to be a complete answer to paragraph 10.
Yeah, quite.
I may have misunderstood what this is all about. I thought you were asking us to set aside our order. Are you also asking us to vary our order? Are you also asking us to vary the recorder's order?
Yes, my lord, that's what the application is for. It's identified the
Oh,
various
it's both,
paragraphs.
is it?
But and in part, if my lord and my lady go back to,
I thought I was looking at your box 3, and it's whether the Court of Appeal should vary or discharge its order of the 19th of February 2021.
Yeah, the draft order in tab 2, paragraph, page 8.
Oh, I see.
Goes further, in fact.
yes, my fellow juniors reminded me that I think formally our application is for you to vary your order to set aside different paragraphs of the judge's order. Because if we go to tab 6, you can see how your order was drawn up.
Yes.
And that obviously left many of those paragraphs of the judge's order in place, but particularly in relation to costs. In paragraph 5, you ordered that Vodafone paid a further 12%.
Yes, I follow.
So it's sort of they're additive.
Mm-hmm.
But I wanted to do that out of completeness. But again, to be clear, the primary concern is the issue of costs.
Yeah.
So I apologise for taking slightly longer than I'd hoped, but unless I can assist you any further.
Thank you very much, Mr. Hinchliffe. Yes, Mr. Nicholson.
My lords and my lady, subject to any matters that my lords and my ladies would like me to deal with immediately, I'm intending to give a brief overview of how we see the present situation and then focus on the core topics in the order they appear in our skeleton. I mean, specifically, why the cost order isn't unjust, the court's jurisdiction under 3.17, and then finally I do briefly want to look at 5230. And I fully appreciate that at least until this morning my learned friends were at pains to say that their application was under Rule 3. But we respectfully say that a proper understanding of the provisions of 5230 is relevant to appreciating why my learned friends are so keen to avoid it, and why Vodafone's desire to use Rule 3 instead amounts to an impermissible attempt to bypass the strict controls implemented to embody this court's approach in Taylor and Lawrence. Our starting point is there's nothing special about this patent action at all. As was recognised by the Supreme Court in Virgin, the legislature has implemented a patent system which, subject to specific rules, there are parallel routes to invalidate a European patent UK. First before the domestic courts and second before the EPO. And as my lords and my ladies well know, it's very common for a patent which is being asserted and attacked in the UK to also be under attack in the EPO. And we respectfully say that anyone who practices in domestic patent litigation knows about these two routes and routinely has to consider the potential impact of a decision adverse to the patent in the EPO and what impact it would have on domestic litigation. Sometimes the EPO may amend the claims, sometimes the whole patent is found invalid. Sometimes there's a decision which goes one way at first instance in the opposition division, and sometimes the decision is reversed on appeal in the Technical Board of Appeal. And as at least my Lord Justice Arnold will appreciate, there is at least theoretically a further appeal to the so-called enlarged Board of Appeal, but much like our Supreme Court, that only takes cases in special circumstances.
I'm not sure I would agree with the categorisation of it as a further appeal. I mean, it's much more like a cassation in civil law.
I wouldn't disagree with my lord. I was seeking to acknowledge its existence and move on rapidly. Now, unfortunately, one of the potential drawbacks of the EPO, and we've heard about this already this morning, is that the proceedings, not by design but by practice, can often be elongated. And it's not uncommon, as in the present case, for the final decision of the EPO to come after the patent has expired. Indeed, in the present case, the patent expired on the 14th of February 2020, yet the final decision of the TBA didn't come down until the 23rd of January in 2021. Now, it is the parallel feature of the system that now brings the parties back before this court. Broadly speaking, Vodafone lost in the action which proceeded in the domestic courts. It lost partially before Mr. Recorder Campbell at first instance in January 2020 and was ordered to pay a significant proportion of my client's costs by a final order of the 8th of April 2020. It then lost further on appeal, specifically on the Crown use defence for the present panel on the 19th of February 21, and the final order of this court ordered Vodafone to pay a further contribution to my client's costs at first instance and the majority of the costs on the appeal. Now, up until this point, the EPO had upheld the patent at first instance before the opposition division, and the appeal pursued by a related Vodafone company, Vodafone GmbH, was pending before the Technical Board of Appeal. Now, my lords and my lady refused permission for Vodafone to appeal the Crown use defence to the Supreme Court, but Vodafone filed its own petition on the 19th of March. And it's that petition that was still pending when, at an oral hearing on the 23rd of July 21, the Technical Board of Appeal took a different view to the UK courts on a single point of added matter, with the consequence that the patent in all EPC jurisdictions was revoked ab initio, as if it never existed. Formal reasons didn't follow until the 6th of October 21, and for completeness, my clients confirmed on the 28th of October 21 that it would not be seeking to take the matter to the enlarged board. Now, we say that is it, the patent has gone, it's deemed never to existed, and there's no prospect of it coming back. And we're here, though, because Vodafone contends two things. First, it says that the court should set aside all of the relief which was granted in respect of an assumption that it was a valid and infringed patent. And secondly, and we detect importantly, Vodafone wants this court to reverse all of the cost orders made in these proceedings. Not only to recognise Vodafone as the overall winner, but rather it wants to go further and it asks for compensation to Vodafone of its costs which it had incurred on issues such as, for example, the Crown use appeal to this court, which it lost and which formed no part of the EPO proceeding. And just pausing there, before we get into the detail of the mechanisms which my learned friends are seeking to invoke, we say that what Vodafone is seeking to do is directly contrary to the approach taken by the Supreme Court in Virgin and Zodiac. As my lord and my lady may well recall, Virgin arose in quite similar circumstances to the present case. Virgin succeeded against Zodiac for patent infringement in the Court of Appeal, albeit having had somewhat less success on the same issue before my Lord Justice Lewison, as your lordship was then at first instance. Now, after the Court of Appeal, the patent was amended rather than revoked, but with the consequence that the defendant, which was Zodiac, no longer infringed. And the question of what to do about the domestic decision on infringement, which had been overtaken by the EPO, subsequent decision on validity, ended up before the Supreme Court. And I disagree with my learned friend's submissions earlier this morning that that was an appeal taken in the inquiry. With respect to my learned friend, it wasn't. There's no first instance decision in the inquiry, no Court of Appeal decision in the inquiry. The decision was made as an appeal on an application to the Court of Appeal for repayment of monies paid on account. It was
There was an application to the Court of Appeal for that, and also an application under what the then equivalent of 5230, which was refused.
I believe that's correct, my lord. Yes. Now, quite notably, and where we say my learned friends clash squarely with the Supreme Court approach in Virgin, is that the Supreme Court did not consider it appropriate to set aside any of the relief which had been granted by the lower courts. The declarations of infringement still remained, and very importantly, the order for the taking of an inquiry remained. Virgin was still entitled to proceed with an inquiry into its losses if it wished to do so. The Supreme Court effectively recognised that the decisions leading up to the grant of relief before amendment remained correct. It had no hesitation at the suggestion that they should not be revisited as a consequence of the subsequent event of the Patents Amendment. And that's addressed in Lord Newburger's speech at paragraphs 53 to 55 and Lord Sumption's at paragraph 35. Rather, the ratio of the Supreme Court decision in Virgin is that the defendant, Zodiac, was entitled to rely upon the fact of the Patents Amendment on any such inquiry to contend that Virgin had not suffered any damage. And Vodafone's attempt in these proceedings to invite your lordships to reconsider the decisions which have been taken at both first instance and on appeal in the light of the subsequent revocation of the patent, we say is entirely inconsistent with the approach previously taken by the Supreme Court. Now,
So you say that the effect of the Supreme Court decision in Virgin was that Zodiac were permitted to raise a new defence on quantum only, and otherwise the lower court's orders stood.
Absolutely. Now, although we say this applies to all of the relief which Vodafone is challenging, it's most clearly seen in paragraph 30 of Mr. Brown's witness statement, which is at S8, page 101. And I'm looking at the little paragraph E at the top of the page, it's paragraph 30 at the end.
Sorry, I'm behind.
I'm sorry, my lord.
I was making a note.
Bundle S,
Yeah.
it's tab 8,
Excuse me.
and it's page 101.
Yes.
And the argument at the end of E, having set out paragraphs 10, 11, 12 and 13, which my learned friend showed you earlier, were the orders for an inquiry and related directions. The argument is that IPCom is not entitled to damages because Vodafone could not have committed any acts of infringement in respect of an invalid patent. Vodafone therefore asks for this aspect, and that's the inquiry, of the first instance order to be set aside.
So this is the point I was debating a moment ago with Mr. Hinchcliffe. And I assume from what you've said already that you accept that upon the inquiry they can set up revocation of the patent as a defence per Virgin and Zodiac, and they can say that therefore you've suffered no damages. But what you say is that doesn't lead to the consequence that they're asking for now, which is setting aside the order.
Your Lordship's absolutely right.
Yeah.
Now, as we've said, the order for an inquiry was the very thing before the Supreme Court. They didn't consider that it should be set aside. And the approach advocated by my learned friends before this court to relitigate each decision which has been taken in the case in the light of the new fact that the patent is invalid is not an approach which, as far as we can see, has heretofore ever been taken. Just focusing on the issue of costs alone and looking at the approach that was taken in Interim, the contention, if one moves from an indemnity whereby all of the costs are ordered in the reverse direction, is that the court will be having to go through each and every cost order which has been made in the case to determine whether it's one that should still stay in my client's favour, or should go as no order as to costs, or should go as some proportion towards my learned friends. Take, for example, the costs ordered by this court in relation to the Crown use defence. That had nothing to do with the validity of the patent. It was a legal point of construction which was taken. It was argued out between the parties. My learned friend's argument was found wanting, and mine was accepted, and the costs followed the event. It is an individual decision, which is more than simply setting aside the order. My learned friends want an active decision on each and every cost order which has taken place in the proceedings. Right. Once one understands that the established position of dealing with parallel invalidity routes before the EPO and the domestic court, one readily appreciates that the approach adopted in the UK is not that the defendant gets to redo the litigation based upon new knowledge that the patent is invalid, or that the claims are in a different form. Rather, the way the UK addresses the situation is that domestic decisions which have become final remain intact because they were entirely right at the time they were made. But subsequent decisions are entitled to take the fact of invalidity into account. Now, finally, before I move on to the specific points, it's important to be aware of the proper way to address potential injustice that might be occasioned by the parallel route. Now, generally, there are two possible ways forward. The first is to stay the UK proceedings pending the outcome of the EPO, and this court has given significant guidance, actually in another IPCom case, and we touched upon it with my learned friend earlier, IPCom and HTC, 2014 RPC, where this court, led by Lord Justice Floyd, recast the so-called Glaxo guidelines, specifically in the light of the Supreme Court's approach in Virgin, as in fact Lord Sumption at paragraph 38 and Lord Newberger at paragraph 69 invited this court to do. Now, we thoroughly accept that a stay is not always appropriate, and certainly Mr. Justice Burse, as he then was, did not consider that the case for a stay of these proceedings was made out, albeit that my learned friend dropped his application for a stay and the judge was concerned really with a question of expedition. But we say a stay isn't the only way to address parallel EPO problems. As Mr. Brown is very keen to point out in his evidence, and it's worth looking at this, it's in Supplemental Bundle, tab 8, paragraph 15. In the skeleton responding to my learned friend's position that there should either be a stay of the proceedings or certainly not expedition, Mr. Brown is keen to point out that IPCom specifically said in its skeleton on the hearing before Mr. Justice Burse that the alternative way to deal with potential injustice was to make provisions in the final order. And indeed, we say it is open to a party to argue that there should either be a stay of the proceedings pending the EPO, or if the patentee insists on proceeding to a domestic trial, undertakings can be requested to compensate the defendant for losses it would sustain in wasted costs in the event the EPO subsequently renders the domestic proceedings a waste of time.
That would, so to speak, be the price of a refusal of the stay.
Exactly, my lord.
I mean, it's not an exact parallel, but if you want an injunction, you've got to give a cross-undertaking in damages.
Absolutely. Absolutely. And your lordships may have noted that is in the IPCom guidelines expressly.
Yes,
number 7. Undertakings may be required. And we say this whole approach stems from the dicta in Virgin, and particularly Lord Sumption's paragraph 36, that recognised that the court might be faced with difficulties if an inquiry has already completed and monies have been paid. And the answer is to ensure either that the monies are not paid before the EPO proceedings complete, or are paid subject to some form of undertaking to repay or to have an ability to bring the matter back before the court. And we say there's no reason in principle why the same condition cannot be applied to costs if the patentee, as my clients did in the present case, wanted to press on regardless of the potential for wasted costs. Some protection for the defendants ought in principle to be possible. But the problem in the present case is that despite my client explaining what the proper approach was, and the message clearly having been received by Vodafone's solicitors, because Mr. Brown says it was, Vodafone never did anything about it. And it's apparent from paragraph 16 of Mr. Brown's witness statement over the page that not only did Vodafone not press any application for a stay of the proceedings, it didn't press any cross-undertaking in costs in the event that the EPO proceedings rendered the domestic proceedings moot. And of course, Mr. Brown is here talking about the hearing before Mr. Justice Burse. But the same goes for the final order hearing before Mr. Recorder Campbell, and the submissions on the form of final order before this court. Vodafone never asked for a protective proviso in the event of invalidation by the EPO. And the consequence, the IPCom was never put to an election as to whether it wanted to proceed at its own risk of having to compensate Vodafone in some way in the event of an adverse decision before the EPO, or whether it would accept some form of stay or other approach. And I emphasise put to an election and in some way deliberately, as the decision to be taken and the potential compensation to which IPCom would have been exposing itself clearly varied throughout the case. For example, by the time of the final order hearing before Mr. Recorder Campbell in April 2020, the patent had expired. Now at that point, injunctive relief was out of the question, and there was no need for IPCom to insist upon the parties incurring costs on the original appeal until after the EPO had completed. And indeed, as my learned friend showed, my lords and my lady, a letter was written from his side of the court saying, do you really want to get on with the appeal? And my client said, well, yes, we do. But they were never put to an election. It was never said on Vodafone's part, well, this will be at your own risk as to costs if the EPO at some point in the future decides that your patent is invalid. And had my learned friends sought that sort of proviso relief and had put IPCom to an election, cross-undertake on Vodafone's costs or stay the appeal, it's entirely possible, and I put it no higher than that IPCom would have been prepared to wait at least for the appeal. The considerations undoubtedly are different at first instance, where my client was seeking to get an injunction before the expiry of the patent. But just giving the example of the Court of Appeal hopefully illustrates to my lords and my lady that when an election arises because the cost of the course that my clients wanted to take is made clear, that's the time at which a decision can properly be taken. And instead, what my learned friends' clients have done is allowed the final orders to be entered, both at first instance and on appeal to this court, and indeed in front of Mr. Justice Burse on the expedition, without any provision for recovery in the event of an EPO revocation or amendment. And it is important that IPCom was saying since the outset that Vodafone could, what IPCom was saying since the outset that Vodafone could do is actually precisely what Milan was planning and submitted to the court before Mr. Justice Marcus Smith in Interim. And we've quoted that at the top of page 5 of our set.
I think we've got this point, Mr. Nicholson.
Yeah, my lord, I am grateful. And we do say they come now with hindsight, belatedly, asking the entire case to be reopened, starting with the appeal, but feeding down into the first decisions, to retrospectively put in place and activate the provisions which it was fully aware of and could and should have dealt with at a much earlier stage.
Well, those are all reasons why we should not vary the order if we can.
Absolutely.
If we can vary it.
But it sets the context as we come
Yeah.
into all of this. Now, I mean, why the cost order itself is not unjust, I'll take this really quite quickly because I think your lordships and my lady have the point. There was nothing wrong with the proceedings below. Nobody has ever said there was. The issue-based cost assessment followed the event at each stage of the proceedings. And on the basis of Virgin, the exercise is not to reopen and relitigate as if the EPO was known at the time. And we do say that although analogies are fraught with danger, the situation is actually not dissimilar to interim cost orders which are made in the course of proceedings. A party that argues a point and loses it on some interim application will usually pay the costs of that point having been run, irrespective of whether or not they're the ultimate winners at trial. And here Vodafone say they're the ultimate winners at the end of the day because of their success in the EPO. But that tells us nothing about costs that were rightly ascribed to the winner of parts of the litigation in the domestic proceedings. I mean, continuing the analogy, the court recognised that sometimes mid-stage cost orders do depend or should depend on the ultimate winner. We're all familiar with claimants' costs in the case, defendants' costs in the case, or even costs reserved to the judge hearing whatever the relevant stage, subsequent stage might be. And it's by these types of order, which are entirely well recognised, that can be made so that justice may require an ability to determine final costs at some subsequent time. And we say that's directly analogous to Vodafone saying in the substantive proceedings the cost should be awarded with a provision in the event that the patent is lost or materially amended in the concurrent EPO proceedings. What one doesn't do is lose all the interim arguments, lose all the interim costs, and then not appeal any of them, and then turn up and say to the trial judge, after winning the overall action, that the case should never have been brought, and invite the trial judge to rescind all of the earlier orders. Now, before I pick up this point, I should just pick up a position on Interim, which is paragraph 18 of our skeleton. My learned friends notably relied on the decision of Mr. Justice Marcus Smith, in the first instance in Interim, in its grounds in support of notice to appeal to the Supreme Court. That's paragraph 9 of the grounds that my learned friend showed you earlier. Now, although they acknowledge that an appeal is pending, we say my learned friends don't seem to have reconsidered their position in the light of what happened on appeal. Your lordships, I think, are familiar with the way in which Interim developed. But the point being that it's not the case that when this court didn't approve of the position that when the patent is revoked by the EPO, an indemnity arises against the patentee. On what the court, with respect, held is that in that particular case, where there was a route for the court to look at it, one has to look again at the discretionary issues of costs and work out what should happen. Now, we say that Interim really doesn't help my learned friends because it's not concerned with any relevant issues of jurisdiction or reopening of sealed orders after the court has become functus officio. The case was still pending before the High Court when the TVA decision was handed down. The costs order was made within the judge's first instance jurisdiction without having to reopen the proceedings, although I accept there was a side issue of the barrel jurisdiction, such that the case had almost left the judge's grasp, but importantly hadn't. And likewise, when the Interim case came on appeal before this court, It was a normal appeal, made in time, asking this court to review the cost decision of the lower court. Again, no material jurisdiction issues applied. So we say Interim is not authority for the proposition that subsequent revocation by the EPO leads to an indemnification of all costs. And it certainly isn't an authority for any proposition about a jurisdiction to reopen proceedings in any material way, as my learned friends need on its application. And we say that my lord and my lady are not going to find very much of his assistance in Interim, save that it was this court's view that invalidity leads to indemnity costs is an erroneous approach. And very much as a side point on the facts, it's clear that parties are aware of the need to make provisos in final orders when parallel EPO proceedings are underway, because that's what Mr. Justice Smith was being asked for when the TBA, up to the point where the TBA decision came down. So that brings me to 3.17. We've got 3 points. First, the general provision cannot be relied on to circumvent the express provisions governing the reopening of appeals. That's 5230. And both sides agree, albeit for different reasons, that 5230 cannot assist Vodafone. Our second point is the general provision, that's Rule 3, does not apply to the reopening of final orders, save in the most exceptional circumstances. And we say, my learned friends, don't get close to justifying this being a most exceptional circumstance, although I took from my learned friend's submissions this morning, he seeks to say that the EPO regime is exceptional, which we
What's
disagree.
the difference between exceptional and most exceptional?
Not materially, my lord. And then my learned friends has the William authority that you didn't address your lordships on orally. We say, rightly so, it doesn't assist him, and a couple of other authorities which he's slipped into the bundle during the last few days. So just on circumvention, we picked this up for your reference at paragraph 23 of our skeleton. The unsurprising proposition comes directly from the very recent authority of this court, led by the Chancellor in Ceredigion and Pope. We've quoted the relevant legal discussion of 41 to 43, and your lordships are familiar with it. The residual jurisdiction of the Court of Appeal to correct injustice recognised by the court in Taylor and Lawrence was subsumed into 5217, now 5230, and there is no inherent other jurisdiction, including Rule 3, and that was the point that was being pressed on the Chancellor. Ceredigion is squarely on point, looking at Rule 3 and 5230. But this isn't actually the first case that's made the point about using Rule 3 to bypass self-contained regimes. Indeed, a little later in our skeleton, at page 11, we pick up Terry and BCS from this court in 2018 on the same point. And in our paragraph 25, we've quoted Terry, and I draw your lordships, your lady's attention to the attempt in Samara to use 3.17 to bypass the self-contained regime for setting aside default judgment under 13.3. Now, by analogy, 5230 is a self-contained regime for reopening an appeal. It's precisely this same point, but in the context of a different regime. And we respectfully say that without inviting this court to depart from the very recent decision in Ceredigion, my learned friend's reliance on Rule 3.17 is, with respect, we say, bound to fail. The second point is that this doesn't apply, Rule 3 doesn't apply to final orders. And the basic point is that the general power under the rule enables the court to revisit previous orders whilst it retains power and control over the case pending before it. Once the court is functus officio, the case is no longer pending before it, and the flexible tool to reconsider matters is no longer either needed or appropriate. And we say that's precisely what the authorities establish, and this court clarified in Ralt and Northwest Strategic Health Authority, from which we've quoted on page 10. Anything else would amount to a power for a judge to hear appeal from him or herself in respect of a final order.
Is Ralt quite as absolute as that?
My Lord, we say it is when you actually dig into it. I was going to deal with a couple of the little authorities that come out on the back of it. There are circumstances where the court will look at orders. A number of them come from family proceedings, where in fact when one looks at the cases, there is an express ongoing power or duty in respect of the court. Or there's another case which we'll look at briefly, where a default judgment had been entered, and there's an express route in the court rules allowing for a default judgment.
I think Lord Justice Hughes talks about orders with continuing effect, like injunctions. I think specific performance is another one.
My Lord, I think that all comes down to the same area, that where there is a retaining of power and control.
If the order hasn't been fully worked out.
Exactly, my Lord. It's got to be supervised by someone. And if there is an ongoing, effectively supervisory capacity by the court, then it's obviously right and proper that the court can, within properly circumscribed bounds, retain control over the situation. But here we're talking about orders which have been sealed, which have been complete, and have actually moved on to the next stage of appeal.
I mean, of course, the court potentially would have jurisdiction under 5230, even if it was, to use your expression, functus officio, because that's the very circumstance in which you can come back to court.
Absolutely. That is the back door, or front door, or side door. It's there, and the court has lost control and power, save for this specific route.
Yeah, but then, to take my Lord's example, you're then looking at the continuing effects, not the past effects. So take the injunction example. So there was the HFC case, the Cipriani case that came back to me, where there was an injunction to restrain trademark infringement, and then there was a subsequent dispute as to whether or not the defendants were going to comply with the injunction by a proposed rebrand. And very sensibly, rather than going ahead and risking a committal application, the parties agreed that the correct procedure was to have an application within the existing proceedings for a determination as to whether there would be compliance with the injunction or not. But that was all forward-looking.
Exactly.
So it's the point about, yes, the court retains, as you were saying, an element of supervision, but it's not going back and undoing what was done before.
Indeed, because going back and undoing what was done before, or contemplating undoing it, is absolutely the square ground for appeal territory, for saying that the court got the matter wrong on the decision that it made. Notably, one of the points that does come out in Rold is it picks up a misunderstanding that it can be used whenever there's erroneous information or a subsequent event. This court making clear that although these are necessary requirements for invoking Rule 3, they're not sufficient. And if the jurisdiction has ended because a final order has been made, then the jurisdiction no longer exists. And simply pointing to erroneous information or a subsequent event isn't good enough. Indeed, as explained by Lord Justice Hughes in the section we quoted at the top of our page 11, it doesn't follow that whenever one or more of the two assertions mentions can be made, you can return. And the judge goes on to expressly say that he has no doubt that where a final order has been made, merely showing that there was either of the two events is enough. Now, I wasn't intending to trouble my lords and my lady with save in wholly exceptional circumstances, because I understand that my learned friends didn't seek to say that this common occurrence in the patent world was wholly exceptional.
Well, on the contrary, he did.
I was going to say, my learned friend has developed his argument this morning, and he does say now it is wholly exceptional. And he points to Unilin, Virgin, Neurim, and the present case of where this has come to a head. But what he skips over is all of the other cases where there are parallel routes, and parties very sensibly deal with them. They arrange for provisions where matters can be taken care of. It's there in the rule or in the guidelines on IPCom. Practitioners are fully aware of them. We've ended up in a situation here because my learned friends haven't taken the usual precautions. And in the normal case, there's discussions between the parties as to whether or not one side wants to press on. And when the other side says, well, I want a cross undertaking in costs or damages or whatever, people reconsider the situation and we don't end up in the mess that my learned friend now finds himself in. Yeah. Now, I touched on this very briefly.
Well, how long are you going to be, Mr. Nicholson? I see the time.
My lord, I've probably got about 10 minutes.
And in reply, Mr. Hinchliffe?
3 or 4 at the moment.
All right. Shall we carry on? Yep, carry on then.
Right, I'm grateful, my lord. I touched on the 2 cases, one in family proceedings that's mentioned in Terry. So it's on my page 11 at little b, the underlined section, 3 lines up from the bottom. Express recognition of, and the court retains jurisdiction. Important part of the consideration in Terry in that case. And the first example in the same paragraph 75 is considering, yes, the defendant who fails to attend. And there's express provision under CPR 39.3 for the court to have jurisdiction in those circumstances. I'll deal very, very quickly with the McWilliam that my learned friends put in writing. We say they were right to skip it. It was a very unusual case. A consent order dismissing an appeal had been dealt with in this court. Once a mistake was realised in respect of that, the parties jointly applied to set that aside.
Yeah, so you had a dismissal on paper by consent and undoing it by consent.
Exactly, my lord. And importantly, if one does want to look for any reasoned decision within it, given that it wasn't opposed in any way, is that the point of a final determination wasn't lost on Lord Justice Floyd. He was actually at pains to come on the facts to the conclusion that because it had been entered by consent, it wasn't a final determination consistent with the purpose of the rule, which is one where the court adjudicates finally on its merits. So we respectfully say that doesn't assist my learned friend.
How does that sit with Terry, though, where it was a default judgment?
So the default judgment, the way into the default judgment is that it was under CPR 39.3, and under 39.3 there's an express right for the defendant.
But why does that differ from dismissal by consent? There's been no adjudication on the merits in either case. I just puzzled why Lord Justice Floyd draws that distinction. I mean, he may be right, but I can't at the moment see why he should be.
I don't seek to support the decision in the case. One can understand that when something's been entered by consent and both parties are coming before the court saying...
I mean, it's striking that they don't seem to have been referred to any authority on the ambit of 3.17, but there we are.
So often the problem where one doesn't end up in adversarial proceedings and both sides are inviting the court to take the same direction. But I certainly say it doesn't assist my learned friend. I'll deal with the other authorities that have gone in tabs 11, 12 and 13, I think it is, right at the back of the bundle, briefly. These are all to do with unjust enrichment and the proposition that my learned friends took the Lordships and my ladyship to from Goff and Jones, which is you can't run the unjust enrichment without setting aside the order of the court by which the monies were paid. Well, we don't dispute that at all. The problem is where it doesn't assist him is the mechanism by which one can set aside the order. As my Lord Justice Arnold was discussing with my learned friend, if it turns out to be the case that one sets aside the order, one could potentially then proceed down unjust enrichment. But it certainly provides no assistance to my learned friend other than to say, well, if I want to run unjust enrichment, it must follow that you must therefore set aside the order. We say that's putting the cart before the horse. You've got to show that there's basis to set aside the order, and then if you want your money back, that's when you bring your action for unjust enrichment. So we say it doesn't help him. Then very briefly, under 5230, the reason that I'm interested in this section is it's the only route that my side recognise is open to my learned friend, or is the mechanism he should be putting in place. And why it matters is that my learned friend is not being shy about expecting that there is a probability that this court will refuse his application. What his clients want is a refusal which enables them to go back to the Supreme Court and try again there. And if my clients are right and 5230 is the right route...
Sorry, he wants a refusal of what?
Sorry.
He wants a refusal of the application on the 317.
He would be delighted if my lords and my ladies...
Well, you can't stop that, can you, surely? I mean, the fact of the matter is, there is an application notice before this court invoking 3.17. If we refuse that application, then there is jurisdiction in the Supreme Court to entertain an appeal from that refusal.
The slight... Your Lordship's absolutely right. The slight issue that I'm trying to at least bring to your Lordship's and my Ladyship's attention is that if he made his application under 5230, there is a rule bar preventing him going any further with it. 5230 sub 7 expressly provides there is no appeal from a decision under 5230. And that's really the beginning, middle and end of the point, because I want the court to be aware of that, because especially if this court's view is that the route my learned friend should have taken, as was the court's preliminary view, is 5230. My client has been vexed by him not to...
Well, to be sure, but the point remains the same. You're absolutely right, of course, about 5230's paragraph 7. But their application is under 317, and the Supreme Court does have jurisdiction there.
That may be the case.
I'm not entirely sure I follow this point. How does a provision in the civil procedure rules affect the jurisdiction of the Supreme Court?
So, 52...
I know what it says.
Yeah.
But what power? What power does the Civil Procedure Rules Committee have to circumscribe the jurisdiction of the Supreme Court?
That's something to which I hadn't turned my mind, my lord. It may be something that might trouble the Rules Committee, but they certainly purport to say
Yes.
that's...
Well, I mean, to give you another example, which arises not infrequently, we're quite often asked to enlarge time for appealing to the Supreme Court because somebody says, well, look, here's a rule in the CPR which says you can enlarge time. Well, we can't. The Supreme Court has its time limits, and the Supreme Court can enlarge time, but we can't. I don't at the moment see how anything in the CPR could cut down the jurisdiction of the Supreme Court, which on the face of it is a statutory jurisdiction, implemented by its own Supreme Court rules and practice directions.
I understand entirely the point that your lordship puts to me. I mean, my client's concern arises from a running of a point where the answer to it is that you're seeking to circumvent 5230. And at least on its face, 5230 says if you've gone that route and received a refusal from this court, that's the end of the road. But I do understand your lordship's point. Just on the three limbs of 5230, my learned friend says the reason he can't go down that route is because of the third limb C, that he's got an extant appeal. We say this is inculcating Taylor and Lawrence. The fanciful nature of the appeal is something that my lords and my lady would be entitled to take into account. And we say a pending application to amend the grounds to remove anything about the lower court's decision and replace it with a position on costs has fanciful prospects of success. And the real reason he can't run 5230...
You're talking about the amended grounds of appeal.
Exactly, yes.
Yeah.
His prospect of permission to appeal on those, we say, is fanciful. And the real reason he can't run 5230 is because of the first and the second limb.
Yeah.
The first one being it's necessary to do so to avoid real injustice. There's nothing unjust about a situation which his clients have allowed to develop entirely open-eyed about, and which was properly taken all the way through the proceedings where the risk was well and truly known.
Yeah, well, no, I think we've got your point.
Your Lordship has them, and
But
we say
I mean,
not
on C, we'd end up with a lot of egg on our face if we said the prospects of getting permission to appeal are fanciful and the Supreme Court granted it.
Well, my lord, that follows from Taylor and Lawrence. It also follows in situations where a lower court strikes out or considers striking out a case for having no real prospects of success. Likewise, on permission to appeal, where the trial judge says there's no real prospects of success, permission's granted by the Court of Appeal, for example, and actually the appeal is subsequently allowed. It's the nature of the system, but we do have these provisions where judges in a lower court are expected to take a view as to the prospects in higher courts, and it's common across the rules, and no criticism, I'm sure, would be made if one found oneself in that position. My lords and my lady, I've taken that somewhat at breakneck speed towards the end. I think you have my client's point. Unless there's anything I can assist with further.
Thank you very much.
I'm grateful.
My lords and my lady, just three brief points. The first one, my learned friends sought to rely upon Virgin and the fact that the order for the inquiry wasn't set aside in Virgin, but rather what the defendants sought to do was to be able to rely upon the fact of the revocation. There's two points to that and why it's not an analogy. The first one is that what the defendants sought to do was to rely upon the fact of the revocation, and they didn't try and set the order aside. But the reason why they didn't do that was the one I mentioned in opening, which is they'd been all the way through the liability part of Virgin, and the Supreme Court had refused permission on liability, and therefore the findings of validity and infringement were res judicata between the parties in that case. Now, we're not at that stage of these proceedings because your Lordship's decision is to operate a res judicata against yourselves. So that's the reason why Virgin isn't an analogy, why you can't just say, well, they didn't set the damages inquiry order aside in Virgin, so you shouldn't set any of the orders aside in this case. The second point is a point he made in relation arising from Interim, and effectively my friend's submission was, well, there's nothing wrong with the cost orders that were made by this court and by the judge, and that's effectively a submission that when you get a subsequent revocation of a patent by the EPO, what happens in the UK remains the same and it doesn't affect anything. But our submission's answer to that one is the point that came out of the Court of Appeal in Interim, is that the subsequent revocation is determinative of who the winner is in the proceedings because of the parallel interconnected nature, and it therefore is relevant. And when given that the successful party is a prime determiner of the issue of cost order, it then becomes relevant to reconsider the cost order. And you end up in a situation where you do, in this case, with competing factors, one factor being the success on the issues that IPCom had at first instance and on appeal, but balanced against that, the fact that the entire proceedings have been a waste of costs because of the EPO outcome, and that being a point that we had made, at the early stage, and we had sought to get the proceedings stayed, and it was IPCom's insistence and IPCom's risk that we say that the proceedings went on. So those are the two high-level factors, and your ladyship are aware that my primary position is that we should have order for our cost of the proceedings, but as an alternative, there's always the option of no order to balance those two factors out. And then the...
So does that mean that potentially there will be another hearing before us? Let us suppose that we decide in principle that we will, put it colloquially, do something with the order.
I think there
Then
are
what
only
do we do?
three. Well, there are only three options. I think the first option is think about it and do nothing. The second option is think about it and reverse the costs order the other way. And the third option is think about it and make an order for no orders to costs. Anything in between involves looking at all the issues, and nobody's asking this court to do an issue-based assessment. So those in my submission are the three options. And the final point is if the court thinks it's not able to, hasn't got the jurisdiction to do anything at this stage, then obviously we would want to go back to the Supreme Court. And just to pick up on that, on the point about prospects of an appeal in the Supreme Court, our position is that's not fanciful, because the fact that the revocation has happened, the Supreme Court have hold of the case, and they are perfectly able to allow the appeal on the basis that the patent has now been revoked.
Yeah.
So unless I can assist the court any further, those are my submissions in reply.
Thank you very much, Mr. Hinchliffe. Well, we will reserve our decision. It will not surprise you to know. You will get drafts in the usual way. That will be your opportunity to correct our spelling and our grammar, but not our reasoning, or to raise new points. The draft comes, as you will know, with a strict embargo, which means what it says, so it can only be distributed to those who are on the list that was given to the court before the appeal. We would hope that in the light of the draft judgments you will be able to agree an order disposing of the appeal. But if that's not possible, please make short submissions in writing, and we will make the order that we think is appropriate. Thank you very much.
All right.